Welcome back. Let's now turn our focus to something else. In 2015, leader of the Islamic movement in Nigeria, Ibrahim El-Zakzaky, was arrested after a confrontation with army troops. Since then, members of the Shiite sect have been facing off with security operatives during mass protests, calling for their leader's release. Over the course of 3 years now, the country has recorded deaths of innocent citizens, policemen, Shiite members, and more recently, a trainee journalist. In several interviews with newsmen, the sect has denied all claims of violence during their protests. After disregarding several court orders, the federal government has now gone further to ban activities of the sect. The Inspector General of Police, Mohammed Adamu, confirmed this development.
Although this meeting will review this and other general security situations and in place appropriate action plans that are targeted at addressing this threat, let me affirm that in relation to the Islamic movement in Nigeria, in view of their increasing engagement of terror tactics and other violent and subversive activities which contravene the Terrorism Prevention Act of 2013 as amended and violate the judicial pronouncement of the Federal High Court Abuja on the 26th of July 2019, the federal government has classified them as a terrorist group and has accordingly proscribed the El-Zakzaky-led Islamic movement in Nigeria. In consequence, henceforth, any person engaged or associating in any manner that could advance the activities of the proscribed Islamic movement in Nigeria shall be treated as a terrorist, enemy of state, and of subversive element, and shall be brought to justice within the context of the Terrorism Act. The impact of this is that all forms of procession or protest by Islamic movement in Nigeria is now illegal and thus banned.
Well, El-Zakzaky's lawyer, Femi Falana, has asked the federal government to reverse its order. At the resumed hearing of El-Zakzaky's bill application, Falana says the ban on IMN's activities is an infringement on their basic human rights to freedom of religion and peaceful assembly. Listen to both counsel to the defendant and plaintiff state their positions on this.
They were shot at on December 14, 2015. Up to now, some of the pellets in their bed have not been removed. And that, according to medical reports, has led to lead poisoning in their bodies. In the case of Sheikh, in addition, he has lost an eye in detention and is in the process of losing the other one. And so the doctors are asking for urgent medical treatment abroad, which is unfortunate for me as a Nigerian, that we cannot provide adequate medical facilities for treating Nigerians who are indisposed. The prescription order cannot work. Number one, there is no way under our law that you can determine the rights of a Nigerian without hearing him. It's so elementary that you cannot determine anybody's fate in Nigeria without hearing. In fact, Section 36 subsection 2 of the Constitution prescribes that before the determination of the rights and obligations of any Nigerian or any person in Nigeria, I'm talking of citizens and foreigners, you must hear them. So a court in Nigeria cannot, under the law, proscribe an organization, declare the members terrorists, and ban their activities without the benefit of, without affording them fair hearing. It's not part of our law. Because both Section 36 of the Constitution and Article 7 of the African Charter on Human and People's Rights, which has been domesticated and enacted into law by Nigeria, insist that everybody must be given a hearing before you determine his or her fate.
They filed an application supported by an affidavit and medical report, exhaustive medical report, stating the state of health of the applicant, that's Sheikh Zakzaky and his wife. and all the medical reports were annexed to the application. Look, the medical reports are based on the conduct of examination by his doctors, who recommended a hospital, Indente Hospital in India, for him to go. But the state said, no, we have adequate medical facilities in this country to treat whatever ailment the applicant has.
We've also been getting the reactions of other lawyers as well, and as expected, they've been expressing diverse opinions.
If prescription is what the federal government can do to restore peace, to take those boys out of the street, why not? iPod was prescribed, and today we have relative peace in the southeast, everywhere in the country. What is very important for this peace to last very long, let El Zakzaky be released.
The decision of the government to embark on proscribing the Islamic movement of Nigeria, for me, is reckless and without sufficient reasonable basis for it. It's something that was needless. The group has conducted itself in a peaceful manner. It has been on the receiving end of violence from government forces. The group is making a legitimate claim by requesting and demanding that its leader be released on bail to attend to his health. The various forms of violence that have been associated with all of its protests call for investigation. To unilaterally, without the significant grounds, to proscribe the group is simply a provocation, and without consideration to the need to respect the religious rights of the Shia movement in Nigeria. It is rather exacerbating the problem and creating the impression that the Shia movement in Nigeria is not only being oppressed but now being persecuted. There is no need for that. If there is a law enforcement issue that needs to be tackled, then the investigations should be conducted, and then the criminal justice process will be activated. But to just go and prescribe a religious movement that has not shown any reason or such forms of terrorist tendencies, it's just a provocation and simply justifies the claim that there is a grand plan to oppress them and chase them out of Nigeria, and that is not proper. That is against the fundamental rights of the Nigerian citizen to hold on to his religious beliefs, to practice it, and to express same even when he's dissatisfied.
The federal government has actually responded, saying this is by no means a witch hunt, but a simple case of fighting lawlessness and criminality. Meanwhile, the court has adjourned till April 5 to rule on the bail application. All right, joining me now to discuss more about this is the chairman of the Nigerian Bar Association of the Abuja branch, Barrister Folarin Aluko. Many thanks for joining us on the program today, Mr. Aluko.
Thank you very much. It's a
First, let me get your own personal stance or position on this prescription. What exactly do you make of this particular development?
The prescription of the IMN was done pursuant to the Terrorism Prevention Act. Of course, it's apparent that the federal government is trying to reach a solution, through a diverse number of approaches. Unfortunately, it appears as though the more attempts that are made, the worse the situation gets. But as far as the legality or otherwise of the prescription, if you look at the provisions of the Terrorism Prevention Act, the Section 2 of the Act does allow for the Federal High Court to issue such an order, on application of the Attorney General. And of course, one must consider the fact that the overriding consideration is the security of the lives and property of Nigerians. Of course, the issue isn't a very simple one. There are so many nuances that also touch on the fundamental rights, the fundamental human rights of the leader of the IMN, his trial in court, and the possibility or otherwise of or the failure of the government to either accede to the order of bail, the bail that had been granted to him, you know, or otherwise. So that there are a lot of peculiarities that are playing out in this particular instance. And because, you know, the nature of the case is such that the details of the proceedings haven't been in the public domain, you know, it might be a little difficult to take a position one way or the other. The best option will be for one to ensure that, one, the human rights of the accused person or the defendant, that's the leader of the IMN, is not infringed upon. And so due process must be followed. You know, it's very important that the federal government should show that it is beholden to this higher standard, to the standard of the rule of law. You know, but like I said, there's a lot of conjecture in the media, and it wouldn't be wise to come to a position on the basis of conjecture and rumor.
Indeed, you've spoken about following due court process, and that was the exact words that the counsel to the defendant also said when he was saying that they would challenge the ruling of the court prescribing the sex. But also, let's look at the issue of human rights, as you have rightly raised. This group has, when we look at the freedom of association, that's it on the one hand, and also for El-Zakzaky, who is the leader of the group now, the federal government has continually disobeyed court orders asking for him to be released. And the AGF said recently that the orders were disobeyed in public interest. Is that a legal term? Is that something that justifies the position?
Well, in addition to what you identified as his right to freedom of association, you also have the right to freedom of thought, conscience, and religion. So what that means is, you know, the man has every right under Nigerian law by virtue of chapter 4 of the Constitution of the Federal Republic of Nigeria to choose the religion of his choosing. Now, there are, of course, not all fundamental human rights are, you know, operate as how do I put it now? These rights don't operate in a vacuum. You know, that's, okay, you know, on the one hand. On the other hand, one also has to consider the fact that when a person is accused of having committed an offense, that person enjoys certain presumptions and certain rights. For example, he is presumed to be innocent until proven guilty by a court of law. He is also entitled to those basic fundamental human rights that everyone is entitled to. Now, these include the right to bail, if the offense is a bailable one. And where a court actually grants bail, it's important that the prosecution, in this case, you know, the prosecuting agency, whether it's federal or state, must comply with the bail, with the order granting a person to bail. Now, having said that, I think there's, from the little I have read about the case, or from what I've read, it does appear that the trial, you know, the court that awarded that gave the order for bail is different from the court in which the defendant is being tried. Now, that does throw up certain issues as to which order takes precedence to which. But in the light, or against the context of the Attorney General's statement as to whether the rule of law is subservient or can be subjected to public policy, I will take a very, very, very strong and divergent view to that position. The rule of law is the rule of law. You cannot have the rule of law subject to. That's no longer the rule of law. The rule of law is that due process must be obeyed and that constituted authorities must be obeyed. So if a court gives an order or makes an order, it is the role of the executive, whether or not the order favors them, to give life, to execute that order, to comply with that order. Because the executive itself exists on the strength of the rule of law. Without the rule of law, what we have is anarchy. So it will be, I mean, given that background, it would be a little ironic to say that the rule of law can be subjected to you know, certain other considerations that, you know, are based on the opinions. Because if we're talking of national security or public interest, it is, these are issues that that exist in the realm of what you may call opinion. You know, so the rule of law supersedes the rule of man. And even the president himself is subject to the rule of law. He's subject to the Constitution. He exists as a president by virtue of the Constitution. So it's important that... Yes.
Please go ahead.
Okay, it's important that, one, if there's an order that has been granted, you know, committing the defendant to bail, the federal government must comply with the order and then may choose to appeal that order. But what usually happens is, before a court grants an order for bail or grants bail to a defendant in a criminal matter, the court would have looked at the circumstances of the case. The prosecution would have had the opportunity to present the facts upon which, you know, they are staking their claim, or, you know, claiming that the defendant should not be granted bail. So they have every right to oppose the motion. And if the judge grants bail, you know, haven't heard the motions for and the counters against the granting of bail and goes ahead to grant the bail, then that is law and that is what should stand.
During the rallies in Abuja, we've seen violence erupt and people have died. There's been destruction of public properties. Many people have said that, indeed lawyers too have said that the solution to this would be the release of their leader. Are you also leaning towards that direction? Well,
it's the truth of the matter is that there is no simple solution to this problem, to this issue rather. This is what you get when a problem is allowed to fester for so long without any decisive action. In my opinion, for example, there's no reason, outside perhaps ill health of the defendant, for such a sensitive trial to have lasted for this long. The trial has gone on for very long, quite unfortunately. Now, having said that, there's also I mean, I cannot, it will be, as a lawyer, it will be unprofessional and for me to defend anybody who tries to breach the public peace. The rallies that took place in Abuja led to the destruction of property and to the loss of lives, in fact, including the loss of the life of a policeman, at least one that we know of, and some members of the IMN.
Of course, and a journalist
yes.
as well.
So one must condemn all forms of public violence, either by non-state actors or by state actors against citizens. Now, having said that, it's important that I think I read a notice or something that appeared, was on social media, that was shared by the leadership of the IMN, asking their members to desist from the public protest. It's important. The right to protest is a fundamental human right. It's a part of the right to freedom of expression and the freedom of speech. However, that right to protest, when the right to protest becomes violent, it crosses over from, you know, the expression of a fundamental human right to the commission of an offense. And it's very important that in the process of advocating for the human rights of another person, one must not also commit, you know, end up committing an offense in the process. So as far as the issue of the protests goes, you know, that issue, in my opinion, is a matter for the police. It's a matter that goes to the public safety, public order, and, you know, public peace. So it's a matter for the police. The organization itself, I believe, also has a visibility issue, because there's a perception that among general public that, you know, they may tend to be violent, whether it's when provoked or when unprovoked. Some of the videos that we've seen, you know, on social media show them using projectiles. I've seen, you know, projectiles like stones. You know, I haven't seen any video that shows them, you know, bearing arms or carrying arms yet. But at the same time, it doesn't mean that one has to wait until they start to bear arms. You know, I've been in traffic on one or two occasions when they have passed by, And in as much as they are unarmed, you know, they don't bear weapons, or they don't bear, you know, firearms, at least not visibly, there's still a public...
Like you rightly said, the group has come out to say that they are not responsible for the violence and the killings that we see when they go on their rallies. And it seems nobody is looking into this, saying that maybe they may be right. Nobody's looking into that.
Well, I think that's correct. The rallies appear to be organized. I mean, there's a lot of investigative work that should go into, you know, into this entire process. But like I said, what they are doing is they are protesting what they call the unlawful detention and arrest of their leader, which I think they have every right to, especially against the backdrop of the fact that there is an order from a court of competent jurisdiction committing this person to bail, or ordering that he should be granted bail. You know, and also again, because it's a terrorism related matter, there's a lot of secrecy, you know, surrounding the case, the substantive suit itself. But it does appear as though the defendant is in need of medical attention. You know, so these are issues that go to our humanity as human beings. But at the same time, government does have a responsibility to also maintain law and order. You know, so it's a delicate balancing act. But you know, it's what you get when you leave a problem. You know, when a problem goes on too long, the adage goes, a stitch in time saves 9. You know, you can't start a story from the middle. You must start a story from the beginning. And if we must start it from the beginning, it's important that the federal government must address this issue at the root. And the root of the issue is the trial of the leader of the IMN.
And lastly, how soon do you see us reaching an end to this?
I believe to a large extent the IMN has engaged lawyers, and they are engaging the process, you know, legally, because a defendant who has been granted bail but has not been, you know, released on bail has rights under the Constitution. There's a legal process to follow. Fortunately, the Administration of Criminal Justice Act, and one will need to look at the court processes to know whether the act applies in this instance. Because if we're looking at the Terrorism Prevention Act, of course, the act does apply to federal statutes. But by virtue of the ACJA, you know, and the ACJL of the various states, there's a need and a demand for trials to go on, especially in criminal cases, on an accelerated basis, because we are dealing with the life and the rights of a human being, a fellow citizen, who is presumed to be innocent. So ordinarily, what I would advise, you know, what I would expect is that the trial should be not accelerated, but we should have a speedy trial. You know, it's important that our criminal justice system should be certain, should be definite, and should also be expeditious. You know, so that what should ordinarily be a trial does not become a witch hunt or a persecution. So in my opinion, once the trial is concluded, and a decision is reached one way or the other, then the matter will be concluded. On the flip side, you know, from the administrative point of view, it's very important for the federal government to engage with the IMN. Now that an order has been made by the Federal High Court pursuant to the Terrorism Prevention Act, proscribing the organization as a terrorist organization, you know, what it means is all its members, any member or any supporter, is committing an offense automatically. So I'd expect, and as they say, they are taking it up in court. If they take it up in court and they win, very good. But it's important that they must also respect due process, respect the rule of law, and not take the law into their hands or engage in self-help.
All right, thank you very much for Larry Aluko for your contribution.
Thank you very much. It's been a pleasure.
That's it on the program for today. You can catch previous episodes and more on our YouTube channel and other social media platforms at TV360 Nigeria. On Facebook, we're TV360 Online. Bye, and thanks for watching.